his opinion, the work of breathing was the only thing keeping her alive. And then he gave his opinion, and I have a star next to it here, that, all of that, and he says that in his opinion, Dr. Shokar's verbal order for lorazepam was a violation of the standard of care. So he focused on the verbal order being a violation of the standard of care, and you're saying as a result of that?
He's going beyond just an informed consent. He's saying that actually administering it, whether it was verbal or written, was a violation of the standard of care because it interfered with her work of breathing. And I think that the jury, I think that's a jury question. There's sufficient evidence from Dr. Burdine's testimony to make the lorazepam itself a question that the jury can answer about whether it was negligent for Dr. Shokar to order it, apart from or in addition to the informed consent issue. And that's my position, Judge, and I'll stand on that, and Your Honor can make his decision after hearing from the other side. But even anything the other side, the defendants can say, it makes it a dispute of fact, and the jury, I think, should decide it. That's all I have on the verdict, Judge.
Okay, so let's stay focused on that issue only. I tend to agree with what was just argued, and maybe I stand corrected, and I'm not too proud to say that. So, who wants to go first?
I think to accommodate Attorney Boylan's concerns is too difficult here. I think you just change question A to an and/or question. You find that Dr. Gavin Shokar was negligent by ordering the use of morphine and/or lorazepam. I don't think we have to get into complicated questions about synergy or anything like that, because if they want to make the argument in their closing that all three of these in combination, I mean, that's the synergy. And as far as his testimony, I don't know that there was any actual evidence that there was a synergistic effect in this case. I think it was more in the context of there could be a synergistic effect. So I think
I'm not going to include synergy in it.
Okay, I think the simple fix is, I can't sit here and argue and say that lorazepam shouldn't be included in these breakout questions, since this is the route we're going. So I think it could be handled with an and/or in the first question.
Okay, and in light of our whole thing, I'm changing 1A to 1C, just so that the time works. We're going to start on October 12th, and so the October 12th Precedix is becoming 1A. October 13th Precedix is becoming 1B, and now we get down to the 13th after Precedix is administered. If you follow your line of thinking, Attorney Boylan, so you can argue, there's Precedix on the 12th, and that's a violation for whatever reason. Then all of a sudden there's the administration of the lorazepam and the morphine.
Lorazepam came next, and then the morphine. Yes, Judge.
So what's the harm if we were to say we find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam and/or morphine on October 13th, 2021 to Grace Schara? And you can argue the fact that Precedix is being administered and he orders these two, and the combination of it was the problem.
The harm, Judge, just generally, I am personally confused by and/ors a lot of times, and I think sometimes jurors may be as well, and I don't think there's a harm in a question 1D that says the same thing with lorazepam. We find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam on October 13th, 2021. And that's all. And Judge, I'll leave it in your hands.
Attorney Frankowiak, any thoughts on that?
Relative to that particular change or the entirety of
Yeah,
it?
that only.
Looks like that one would only pertain to Dr. Shokar's question, so I don't think I really have any issues.
Okay, so for right now, what I've done is I've added on a 1C, which would reads, we find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam on October 13th, 2021 to Gray Schara. And then 1D is what was 1A. Our effort is to figure out that it makes sense. I think doing it and/or makes sense too. And they're only going to answer it if they find there's some issue with the care and treatment. Okay. Anything else from plaintiff then, Attorney Boylan?
That's all, Judge.
Just give me 1 second. I want to just get the verdict form back to current. I'm going to start with you, Attorney Guzzi, on questions, concerns, issues with the verdict form as drafted. Do you want me to print off what has been updated so everybody has that in front of them? Or are you prepared to go?
I think I'm satisfied at this point with, aside from my overall set, satisfied with how this section is worded, the addition of the separate cause question. Nothing else makes instructions easier, consistent. The only other comment that I have on the verdict form is the comment I raised in my email last night about separate itemized damage. I don't think that's appropriate. I think if you look at 8 things in 355, talks about the total non-economic damage recoverable for bodily injury, including any action or proceeding based on constitutional indemnification, and any action or claim by a person other than individual or non-economic recoverable for bodily injury may not be on or after all healthcare providers, all healthcare providers acting by where we probably have an argument is, are there separate occurrences? Or is the hospitalization one singular occurrence? And I think that's the more reasonable view. So, if, and I only briefly looked to see if there was anything that would shed more light on the phrase or the use of the term occurrence, and I didn't find anything. I admit I didn't do a deep dive search. But I think if you read that statute in context, I think it is referring, in this case, to the overall hospitalization. So whether, beyond that, there is no instruction that identifies what type of damages you would recover for a breach of informed consent. It just merely says you're entitled to damages. So I think that's a category of damage that doesn't exist. And it's rolled up into the overall non-economic damages available to a patient or an injured patient in the context of a medical malpractice lawsuit.
I'm reading the right document. So you said you sent something last night.
An email when I sent the instructions, I just made the one note that I had concerns about email at the time.
I have it in front of me. So what you were just reading is that instruction 1741?
It's not an instruction, it's the statutory provision. It's with stat 893.55 4B.
893.
0.55 sub 4 sub B.
Okay. So the impact on our verdict form is, you're saying that section B should be eliminated?
Yes. And I think that would also reduce a number of the jury instructions that are proposed in terms of concurrent, non-concurrent courts. I don't think those apply in this type of case. I think the jury considers all of the alleged malpractice as a whole.
We'd agree to remove those instructions on the concurrent and non-concurrent.
Say that again?
We would agree with Mr. Guzzi that we could remove the instructions on concurrent and non-concurrent torts. We'd also agree with Mr. Guzzi that under 893.55 4B, there is a total cap that can be recovered. Under the laws that exists now, on appeal, we're going to challenge the constitutionality of that. But there is that total cap. We agree with him there. But there's separate jury instructions on personal injuries for informing the patient, which is question number 3 to Dr. Shokar, and another different jury instruction for personal injuries for pain, suffering, and disfigurement and death. That's question number 1. But we agree with Mr. Guzzi on most of what he just proposed. We think both those jury instructions should be given and both the lines should be on the verdict.
You're referring to 1741?
1741 would go to question number 3, yes, and 1766 would go to question number 1.
I don't disagree that 1741 says that you are able to recover damages. You're able to recover damages if there is a violation of informed consent, if there's negligence. The problem is, unlike pain and suffering, which has a jury instruction that defines what the jury is to consider in making a determination to award pain and suffering damages, there is no instruction at all that defines a separate category of damages and what a jury should consider in a negligence or failure to or negligent informed consent.
It's the general instruction, which is in the court's instructions on.
Can we just stick with the verdict form? Right. So I want to stay focused. and we're gonna get to the instructions. There's just one thing I need to just make sure of.
And Judge, I'm only referring to the jury instructions in the context of why I think that that category of damages doesn't exist.
Okay, so I think your last issue that you said, Mr. Guzzi, is you have a concern with the way that the question number 8 is worded, and your preference is that line B gets removed, so that all we have is item A, funeral and burial expenses, and item C, past pain and suffering.
Yeah.
Okay.
That's exactly what I think it should be based on 893.55.
One thing that I heard you say, I think, Attorney Boylan, is that you're in agreement to remove the instructions for concurrent and non-concurrent that have been requested.
Yes, Judge.
Is there any objection to that from defense?
No, I think that's entirely reasonable and appropriate. Right.
So let me just change that in our jury instructions. So I'm removing 1722 and 1722A. Is that the agreement?
Yes. I think that would, I think 725 also falls in that category.
1725 also.
Okay, so I will remove those three by agreement.
Just while we're right there, 56 and 57 could also go.
Agree, Attorney Guzzi?
Yeah, yes, based on the verdict form and no claim for medical expenses, this can go.
Okay, and Attorney McCoyak, you agree with those five being removed?
Yes, Your Honor.
See, Judge, the job's getting easier every minute here.
Yeah. Looks like it. So I'm gonna focus on the instructions since we just removed five of them by agreement. So when I get down to the damage is, and you can see I did very little work on it because I'm still confused. I have 1700, that's still in there. 1757 I still have in. Is that needed?
Oh, that's one that's referenced.
You're in agreement, Attorney Boylan?
Yes, Judge.
Attorney Frankowiak?
Yeah, we're talking about 1757, which is the collateral source. Yeah, that would only apply if there's a claim for healthcare expenses, so. Yeah.
Get to damages, the revised instructions, just so we're on the same page. We have 1700, we're gonna have to do some work on 1850, 1855.
Sorry, Judge, 1850 would also go because there's no claim for medical expenses.
No, funeral was in 1850.
Oh,
so
I'm sorry, Joe, you're right.
it's okay, but it could just say recovery for funeral expenses.
1850. Is still in, so we just have three, and we can circle back to that, or we can.
The only question I would have is that there's two instructions on pain and suffering. I don't know that I don't know that both can be given. I think it's just the estate. Grace Schara herself is not a plaintiff. It's the estate of Grace Schara.
That would probably mean the removal of 1766.
Right.
1966 has been removed by agreement, right?
Judge, that's not one we touched, but I would agree to remove that so long as we can make clear in 1855 that Grace's injury includes death. We had this conversation yesterday about, we're not gonna list death on the verdict, but she died. And,
Listed on the verdict in the questions, but not in the one that you were talking about.
in the damage question, so again, it just has past pain and suffering, and then it would be disfigurement or death, and we took out disability. I just think that we're gonna include that or exclude 1766 on her, and only go with the 1855. I just think the 1855 could be modified to include death. She died, and that the verdict question number 8 now could say past pain, suffering, and death.
Agreement?
I don't, I think it's superfluous, and the measurement of past pain and suffering is from the time of the accident until death. Death in and of itself is not a damage. I mean, I think it's pretty obvious to a juror that we're here about a death. And again, in theory, they need to be instructed on what that damage, what to consider the context of death. There is no instruction on that. I think I believe that these jurors are pretty darn smart. I don't think they need to be told that they have to take into consideration, and if they get to the damage question, that they have to take into consideration the fact that she died. They know that.
Okay, let me just work with you, Mr. Boylan. I'm looking at 1855, which is the one you were focused on before with the word death, right?
I'm here, Judge.
In that second paragraph, it's gonna have to be touched up, but it says, you know, sorrow the deceased consciously endured and suffered between the time of the accident, which will need to be changed, and death. Is that what yours says?
Yes, Judge.
You wanted me to change it to add death in somewhere else?
I apologize that we were moving around between the instructions and the verdict, and I got confused on that. And I just think that on line 8C of the verdict, it should also include the word death as it does in 1855.
Do you want another change to the verdict form?
Right.
I think is
Past pain, suffering, and death.
Okay.
I think it should say death, consistent with the instruction.
all right. So I understand the plaintiff wants that issue. The Attorney Guzzi, your last issue is to remove B, and you'll get decisions from me on that, sometime before we finish today. I think that brings us up to you, Attorney Frankowiak. Concerns, issues, arguments with respect to the verdict form as drafted. You already have all your arguments from yesterday.
Sure.
Go ahead.
As I understand it, Your Honor, we've resolved the issue of the damage question, the personal injuries for lack of informed consent. That's no longer going to be an issue.
that's not resolved. That's the one that Attorney Guzzi has outstanding that I said I'm probably gonna keep it in there for right now, then we're gonna do the instructions, and then we get done with the instructions, we'll kind of compare it back to the two.
Okay.
Same with Attorney Boylan's request to have death under 8C.
Okay, that would be one, obviously, I would join in that one, that
Okay.
concern. In terms of the question of Mr. Schara on the verdict, I think just for the purpose of the record, I believe we made the request primarily because of the law, and specifically that would be the CONNAR, CONNAR case 68, Wisconsin 2nd 42. Just by my interpretation, I
The
thought
site,
CONNAR 68, Wisconsin 2nd 42.
okay,
And it's a Supreme Court case from 1975, and there's just a one statement in there that says the only one question must be affirmatively answered by the trial judge before submitting a negligence question to the jury. Is there evidence of conduct which, if believed by the jury, would constitute negligence on the part of the person or other legal entity inquired about? So I think it's not something even that necessarily needs to be argued. We wouldn't have to stand there and say he's negligent. I think that case, though, just stands for the proposition that, well, if there's evidence there, that individual should, even if they're not a party, or if they are a party, or if they're a plaintiff even.
what I want you to do, Attorney Frankowiak, is I'm just gonna grab a pad of paper, and I want you to itemize 1 through whatever number, each item of evidence that you believe would support a claim of negligence against Scott Schara, even though there's never been any pleadings on that. So what came in at trial? Just start me with number 1, without arguing. Just point me in the record where there's evidence of that.
Sure. I think one particular, the start, I guess, was there was testimony that there was a period of time, for example, from about the 28th of September, I think, until the 6th, for a period of 8 or 10 days or something, where Grace was symptomatic but being treated at home with things like ivermectin and things of that nature that were recommended by the FLCCC before any doctor was contacted. And then, of course, then she was brought to the hospital eventually. Now, there was some later testimony that,
If you don't mind, just what I want to do is just give me the number 1 period of time before the hospitalization.
sure,
Number 2,
okay, that was the period of time before the hospitalization.
and so you want us to now talk to the jury about obligations, responsibilities, duties before ever showing up at St. Elizabeth?
No, I'm just saying that you asked me for evidence that was in the record that I think would potentially support that. So, I mean, that's just what I was identifying as something that might potentially support it.
Okay, and it would support negligence? And so I want to go back to the instruction that I read. A person is negligent when he fails to exercise ordinary care. So my understanding from what Mr. Schara testified to is that they went to a concert. At some point, she started showing like cold-like symptoms. They were monitoring it. I think they got on some medication. Then eventually they tested her because they were planning to go to a wedding. When they tested, she came back positive. When she came back positive, they didn't go to the wedding. They stayed home and continued to treat it. They were monitoring her on the pulsometer, the level of oxygen. When that level of oxygen got down to a level of 88, they followed the directives that they were following, and they went to urgent care. Are you suggesting that that is fails to exercise ordinary care from a parent or a guardian or a power of attorney person?
No, in fact, I'm not even saying I would necessarily argue it. The only question is whether the law says that this is a party that could or should be on the verdict.
Okay, so if you're not arguing it and that wouldn't suggest negligence, then what I want you to do, I'm just going to cross number 1 out and say, okay, it's not before a hospitalization. So what items of evidence would support negligence by Mr. Schara? Just give me a number 1.
Okay, well, that was the number 1 because
but then you just told me that is number 1 all of that, and that supports the jury instruction that says a person is negligent when he fails to exercise ordinary care. You think that is a failure to exercise ordinary care.
Well, there was some later testimony that certain things like remdesivir and stuff may have been outside of the I guess window of opportunity, which would begin running at a certain time after symptoms first appear. So that kind of figures into it as well. Like if certain things were or were not, potential availabilities.
But let me just, if you don't mind, if he doesn't know about that at the time, like none of us did,
Mhm.
So you're treating yourself at home, you're following protocols, and when things get to a level at 88, you go to the hospital.
Mhm.
What I want you to do is, if you don't mind, because I don't want to spend all morning on this, I want you to articulate items of evidence, 1 through whatever number, that support a position that that item number is a failure to exercise ordinary care. Okay, because I think what Mr. Schara did is hopefully what every parent did. And I probably didn't do it with that much detail when my kid got COVID. I wasn't monitoring them by the hour and I wasn't monitoring their oxygen. I'd get home from work, I'd say, hey, how you feeling? Do you have your taste back yet? Are you smelling? How do you feel? Did you get your homework done? That kind of stuff, which might be negligent according to you.
Well, understandable, and these certainly are all things that a jury would. These are all great arguments that a jury could certainly discount these things. Absolutely, I'm not saying that these are not absolute things that jury could consider.
Yeah, and I'm not asking for things that are discount or not count. What I'm saying is, let's just go to the law in the state of Wisconsin,
Sure.
the jury instruction, and then tell me the items of evidence that would support that.
Okay. The only other things I would say, Your Honor, would be there was an issue of the tocilizumab, whether or not that was offered, but it was specifically denied. He certainly has explained why that was, and that's perfectly illegitimate. I think a jury can certainly say, you know what, you had every right to do that. Anyone would have done that. Absolutely. The last one I would say would be the issue of the ventilator once again. Again, no one has put that into an opinion that he was negligent for this reason. Of course, no one's going to argue that. It was, however, that there was testimony that it was offered. It was said this is going to be, her condition is concerning, and she can go at any time, and we have to know what you want us to do. And there's been testimony that ventilators, from his own experts, that ventilators were typically used even in their own hospital. Everybody used them. It was known they were effective, things of this nature. He has said that he did his own research and came to a different conclusion. Whether it's argued or not by any party at the jury, I think there's some evidence in the record that would suggest that maybe that was not a decision based upon his research that would have comported with the standard of care, ordinary care. So I mean, that's it really. I mean, those are the big things. They weren't specifically argued as a point of by any expert, but they came out in the course of the testimony, and that's the only reason we suggested it, because I concede no expert has come out and said Mr. Schara was negligent. This is just stuff that came out in the course of the record, and for the purpose of the record, I just thought I needed to mention that the Conar case exists, and that was the justification we were using for asking for at least proposing that this be there. Certainly, it's up to the court's discretion and whether this particular party goes on the record. But for the purpose of the record, I wanted to indicate that the Conar case was there, and that was the interpretation of that case that we used in order to suggest this in the first instance.
And all the Conar case stands for, I think, is the principle that a trial court judge should look at the only question for a trial court judge is if there's any amount of evidence that would support a finding of negligence against the person, and if the answer is yes, then you would include that on the verdict. That's kind of what it said.
Yes. Is there evidence of conduct which, if believed by the jury, would constitute negligence on the part of the person or other legal entity inquired about? That's the basic proposition for which the case stands.
And that's what I'm doing right now with you. So, and there's 3 things that you've identified. The
right.
One, which is pre-hospitalization, I don't find that's any support for a finding of negligence. And I'm just following the instructions. So now we're down to the last 2, which is the medication that was denied, I believe, on October 6th or October 7th, early in the hospitalization that you mentioned. And
right.
then on October 13th, the decision to not be put on a ventilator or to not be intubated. I'll let you finish talking with co-counsel.